Hello everybody and welcome back to the channel. It's another day, another case, and today we are going to be talking about Washington v. Davis, which is a case that makes the distinction between discrimination in intent and effect in a law. So before we hop into the discussion itself, do me a favor, as always, if you haven't hit that subscribe button. If you like the video, give that like button a little bit of a hit. I do appreciate those of you that hit the button for me. It does push the case out with ye old YouTube algorithms because, as we all know, algorithms are life. And now that I'm done shamelessly plugging myself, let's talk about Washington v. Davis. We start out with two particular individuals named Harley and Sellers. Both were black men in the Washington, D.C. area, and back in April of 1970, they filed suit against D.C.'s police department, alleging that the police department's recruiting procedures, which included a written test, were racially discriminatory and as a result violated a series of laws, including the Fifth Amendment to the Constitution and something called Title VII. Now, this recruiting procedure in total included a 17-week training program. There was physical and character standards they had to meet. You needed to have a high school diploma or an equivalent, and you had to score at least a 40 out of 80 on the particular test at issue, which had been generated by the civil service and was used to test certain verbal abilities. And the rationale given by the police department for this test was you want police officers who are able to communicate clearly and effectively at least a certain level. The response on the part of these two individuals to that was that the test itself bore no actual relationship to the job performance, the actual action of being a police officer, and it ended up excluding a disproportionate number of black candidates, and as a result, it was inherently discriminatory. Now, at the lower court level, the government actually won. They got summary judgment because the court found that there was a lack of intentional discrimination. Instead, it went through a discussion and looked at a series of findings about the number of black applicants, where the police were recruiting, how many people actually got through, how many showed up after having passed the test, and how many didn't, and the fact that the test was actually not specifically designed to exclude black individuals from passing it. And they found that while, yes, indeed, there was a discriminatory effect, and it shifted the burden then to the government to prove the fact that it was not racist, there was no finding there. Summary judgment was approved. Things got a little crazy there at the appeals level, and they were looking at Title VII, which deals with hiring practices and the like. And the court there reversed the lower court, and they said that you cannot use tests that operate to exclude members of a minority unless the employer is able to demonstrate somehow that the procedures and the test itself are substantially related to the job performance. And as a result of that, the appeals court was basically saying, quite explicitly, that discriminatory intent is irrelevant. Discriminatory effect is where they were going to be hanging their hat. And in this particular case, they said that for every one white individual that failed the test, 4 black ones did. And as a result, that was a sufficient finding of racial animus in effect. And so it was an impermissible test. You can tell right off the bat where it is the Supreme Court is going to go, because they open the discussion up with, because the Court of Appeals erroneously applied the legal standards applicable to Title VII, we reverse its judgment. And it just got a little bit worse because the court explicitly says that the petition for certiorari itself does not and did not present grounds for reversal. But the Supreme Court has a particular rule, which is 41D2, which provides that the court may notice a plain error not presented, as in, this is so bad, we're gonna fix it ourselves. Now remember, we're looking at a constitutional standard here, and the appeals court applied a Title VII, which is statutory ruling. And the Supreme Court said that the appeals court interpretation that the purpose of the test, this civil service exam, was irrelevant and focused instead on the impact was not the constitutional standard and never had been. The court had never held that the standard for adjudicating claims of invidious racial discrimination is identical to that in Title VII, and they actively were refusing to do so in this case. The whole purpose of the constitutional discussion is to prevent official conduct which is discriminatory based on race or other immutable characteristics. That is a different discussion than Title VII. The court actually goes through a fairly long list of prior cases, and I do recommend you go take a look at them. There's some interesting conversations in there. But they said that none of the cases before had embraced the idea that an act or law, without regard to whether it reflects a racially discriminatory purpose, is unconstitutional solely because it has a disproportionate effect within different racial groups. But in taking a look at the prior cases, things like jury exclusion, school segregation, and the like, none of them had embraced the idea that an act or a law, without regard to whether it reflects a racially discriminatory purpose, is unconstitutional solely because it has a racially disproportionate impact. Instead, the court had said that a purpose to discriminate must be present, may be proven by systematic exclusion of access of the particular target race. Again, school segregation, jury exclusion, treatment limitations, etc. That doesn't mean, however, that a racial purpose didn't have to be expressed, as in it didn't have to sit and say, we are going to expressly limit this group. Nor did it say that a disproportionate impact was wholly irrelevant, such as applying a facially neutral law in an invidious and discriminatory way. But the invidious behavior can be found in the totality of the facts, but it still needs to be there, and you need to be able to demonstrate it. Simply seeing a disproportionate impact is not the same thing. The court then turned its sights to the concept itself that the appeals court was trying to put forward, that intent, that purpose was irrelevant. And they found several concerns and questions that were raised in that evaluation. First, they looked to the fact that it seemed difficult to understand how a law or a test that established a racially neutral qualification for employment is nevertheless racially discriminatory simply because a greater proportion of one race, here black individuals, failed the test in comparison to others. The test at issue, this verbal civil service exam, cared about a degree of verbal skill, a certain degree of verbal fluency, not the taker's skin color. And they further did say that the government has an interest, a valid, recognizable interest, in employees having a certain degree of communicative and other verbal fluencies. The court also pointed out that the facts before them failed to show that the disproportionate effect was because of an intent to discriminate. The test itself was actually facially neutral, and as a result, there was no basis to sit and say it was attempting to discriminate against anyone, other than perhaps those lacking verbal fluency. The court then turned its attention to the requirements of Title VII itself and found that, at least in this instance, they were not willing to apply a more probing judicial review found in that title to the constitutional questions of the Fifth Amendment and the special racial impact analysis that they were engaging in here. The concern that they end up raising is that a rule that a statute designs to serve neutral ends could otherwise be invalid absent, compelling justification, where it affects one racial group more than another in practice, and this would raise serious questions over a whole range of issues, things like tax laws, welfare laws, public servitude, licensing laws. Just because a law would have a disproportionate effect on one racial group or another could end up invalidating it under this standard, and that would cause widespread difficulties. They even went so far as to say that that sort of structure could end up being more burdensome, particularly to the poor, and as they put it, the average black individual, more than affluent white ones. though they didn't really expound on why, which I find interesting because that's an odd statement to tack on to the end and leave just hanging there. Taking the totality, the court found that the original court, the lower court judge, had rightly found that the tested issue was directly related to the requirements of the police training program, as a certain modicum of verbal ability is essential for police officers to do their job well, and that the positive relationship between the test and the training program performance was enough to validate the test for Title VII purposes. The parties here wanted the Supreme Court to send the case back to the original judge for further findings and further inquiries. But the Supreme Court said, no, that's not appropriate. We're not going to do that. They said that the district court's judgment was warranted by the record before it, and there was no good reason to reopen that case, particularly where there had been changes to the training program that occurred after this suit was initiated. And as a result, they would be opening up an inquiry into something that no longer existed. And so the Supreme Court simply reversed the Court of Appeals decision in this case and reinstituted the district court's judgment. So that is Washington v. Davis. In short, a law can have a racially discriminatory effect and be legal. It cannot have a racially discriminatory intent and be legal. That's the takeaway. That is the basis of law, at least at the moment, to the best of my knowledge. If anyone is seeing shifts in the case law on this, please, please, please let me know. I would like to see it, and maybe I'll do another video. But let me know what you think of the judge's findings below. Is there a difference between racial intent and racial effect? If so, what is it? If not, why? I'd love to know what you think, but until we are together again, I hope everyone is well.